How long is your license suspended for a DUI in Indiana? Well, like most things in life and in law, it's complicated. When a person's arrested, if they agree to take a chemical test and the chemical test had results of 0.08 or greater, either blood or breath, the Bureau of Motor Vehicles is going to impose a 180-day license suspension. Now, some judges will impose a suspension even if there's no results because they think that the arrest is enough to impose a suspension, but those judges are actually in the minority, and most judges are going to require results to suspend the person's driver's license. Now, that's assuming that the person agreed to a chemical test. If a person refused the chemical test and the officer went out and got a warrant, or, in some cases, don't even get a warrant, they just say, okay, fine, you refused, I'm going to arrest you. If you do a refusal, if you have no prior DUIs, then your license is going to be suspended for 1 year. If you have a prior DUI any time in your life, even 20 years ago, your refusal suspension is going to be 2 years. Now, that's just when you're arrested. If you're convicted of DUI, well, then the maximum license suspension is the maximum time in jail for the charge. For example, a Class A misdemeanor is punishable with up to 365 days in jail. So the maximum license suspension for a Class A misdemeanor is 365 days. Likewise, a level 6 felony, maximum time in jail is 2.5 years. The license suspension for a level 6 felony can be 2.5 years. Now, these license suspensions for convictions, those are served consecutively right after another with the refusal. And so just understand that, because sometimes people get upset. What do you mean I have 2 years suspension? I already did a year. They're consecutive. You have to serve them one after another. Now, minimum license suspension. The law changed 2014. The minimum license suspension for a DUI is 0 days, unless at any time prior in that person's life they have a prior conviction for a DUI. Then the minimum jumps to 1 year. The only really good news for Indiana driver's license is if your license is suspended at the beginning of the case when you're arrested, that time goes towards any license suspension post-conviction. So say you plead guilty and the judge suspended driver's license for 1 year, but it took 90 days to get the trial. So your license suspended when you got arrested for 90 days. When the judge convicts you and imposes a year suspension, it's going to be year minus 90, what you already did. So that's huge, obviously. Most of my clients, though, need to drive. We don't live in New York City or even Chicago. We can't just hop on a train or a bus too conveniently. And so specialized driving privileges do exist, and specialized driving privileges are a game changer. They allow you to drive to and from life's necessities, work, school, grocery store, stuff like that. Very important to understand not all judges grant STP, and the ones that do, it's completely up to their discretion. So it's important to get an attorney that is unfamiliar with the county and the prosecutors that the DUI is pending in. If you have any questions, give us a call. I love talking about DUI defense, driver's license issues related to DUI, anything DUI basically. My number is 317-632-3642. And remember, always plead the fifth.